Good afternoon. Mr. Hibner, would you please call the next case?
Regions Bank versus the Blumberg Trust et al.
Let's see, Mr. Thompson
He's muted.
for the appellant. Mr. Thompson, you're representing the appellant?
He's on mute right now, Your Honor.
Oh,
Nick, can you unmute him?
Asked him to unmute. He's going to have to do it with the mouse there on your taskbar on the bottom, Mr. Thompson. It should say mute, unmute.
can you move your chair a little closer so we can see you?
I think he's having trouble with the mute button.
He's getting technical assistance.
There we go. I think that may have worked.
That's it.
Okay. All right. Try this.
Okay, can you hear me?
No.
Yes.
You can, okay. Thank you.
Would you please introduce yourself?
Your Honor, my name's Lance Thompson. I'm a member of the Davidson County Bar. I'm here to represent my client, Edgefield Holdings. I would like to have 10 minutes and then 5 minutes for rebuttal, if that's okay.
All right, sir. You may proceed.
Thank you, Your Honor. I'm going to start with just facts of this case and try to be brief on those. In 2014, Regions Bank filed a complaint against the appellees based upon a promissory note that went into default. To that complaint, they attached an exhibit which was a deed of trust, established that the property was owned by Blumberg II Trust and John Allen. The Blumberg Trust was actually identified 10 times in that exhibit to the complaint. That lawsuit entered into a default judgment in October 18 of 2018. In July 1st of 2019, that judgment was sold to my client, who is the assignee of that debt. So to narrow the issue in this, it's really two-part. One is whether the trial court erred in not allowing my client to be substituted or join in the caption of the case so that they could enforce their judgment under Rule 69 of the Tennessee Rules of Civil Procedure. And the second issue is, based upon the complaint and the attachments and the allegations, was this cause of action correctly identified against the Blumberg II Trust? So I'll start with Rule 15 is the rule that we moved to seek joinder or substitution. We also sought intervention to do so that my client's interest could be protected. So under Rule 15, we're under an abuse of discretion standard. There's generally the trial court will be upheld unless there's certain criteria that are met to establish that there was an abuse of discretion. So on this first issue, Tennessee Supreme Court has held that pleadings may be amended before trial, during trial, after judgment, even during appeal. The case of Branch v. Warren says that leave shall be freely given. As I stated, in October 2018, a judgment was entered for $193,000. That judgment is final. My client owns that judgment and is just seeking enforcement of it. Now, the trial court respectfully abuses discretion by applying an incorrect legal standard. Essentially what they said is that because there was a final judgment, the caption could not be amended at any point. The case was over and done, and there was nothing that could be done about that. We couldn't even, as our alternative relief, seek to join as the assignee just so we could enforce our interest. And there's a reason that we would want to do something like that. For example, we would want to send subpoenas out for post-judgment discovery. I can't sign off on those under Regents, who was different counsel in this case. I have to do it under my clients. So it's really just to clean up the caption of the named party and be able to use the rules of civil procedure to enforce that judgment. As far as the second issue of how the trial court abuses discretion, it relied on erroneous assessment of evidence. In this case, in my motion that I filed to correct the caption, we attached the assignment, which showed that my client did own that interest. That Regents no longer had any interest at all in this judgment. So this was a property interest that did belong to my client. And third, the trial court's reasoning caused an injustice to my client because the court essentially said that we could not proceed under Rule 15. We could not proceed under intervention. There were no rules of the Tennessee Rules of Civil Procedure that allow my client to enforce this judgment. For that reason, the trial court should be overturned on that one issue. As far as the second issue is concerned, the trial court abuses discretion by not allowing the Blumberg II trust to be substituted as the proper party defendant. So the caption of the case originally said the Blumberg Trust. And when that was drafted by Regents Counsel, it should have had a number 2. The number 2 was missing from the caption. But as I stated, the attached exhibits showed the deed of trust and also an affidavit from Regents that showed it was actually the Blumberg II Trust. And according to Rule 10.03 of the Tennessee Rules of Civil Procedure, the attachments to a complaint become part of the allegations. So they were identified throughout the pleadings. Approximately with the deed of trust and the attachments alone, I think we're talking about 20 pages total in addition to the few pages that were part of the actual pleading under the caption. This case is actually very similar to a case called Grantham, which I found, Grantham versus Jackson. In that case, the defendant that was sued was Jackson Madison County General Hospital. However, what was missing from the caption of the case was the word district. But when you looked at the allegations, the court said, no, this was clearly against that defendant. Just having that misnomer or that missing part of the caption did not defeat the cause of action that was pled. In the case of Gross versus Hutchins, the Tennessee Supreme Court said that Rule 10 is merely a technical requirement. It does not control who the case is actually against. I found another case too, Southwest Motor Freight. They mentioned two prongs to look at in determining whether or not who the proper parties were, basically. It says whether the unnamed party knew the plaintiff's action was intended as a suit against it, and whether the unnamed party was prejudiced by the omission of its name in the caption. Now, as I stated,
Thompson,
yes,
you filed a motion to intervene in the case pursuant to Rule 24, is that correct?
intervene and for substitution of the parties. That was part of the top middle caption. And so first part of the motion was so my client could intervene if he under that first section, just to become a party and have an interest of standing in a suit. And then the second part of that was under Rule 15 to correct the caption and the mislabeling of the defendant, the Blumberg Trust.
Did your motion reference any rules other than seeking relief under Rule 24?
Rule 1503.
That was in your motion?
Where in your motion is mentioned 1503?
Where it's under the second section that talks about substituting the Blumberg Trust.
I don't see any rule mentioned.
Well, I know we cited Biskin versus Brown. That also dealt with Rule 15. I know it is mentioned in there.
You said
I do not have a copy
isn't.
that we did mention it. Because we've got a motion and we also have the brief that's attached to it as well. The motion, I believe, just incorporated the brief, but maybe I was misspoke. The brief says Rule 15.
Okay.
So basically, the plaintiff, in this case, we moved for an order for substitution to correct the mislabeling of the complaint. And so what we end up with is the Blumberg 2 Trust mentioned 10 times, like I said. And even in the pleadings that were filed in the trial court, the appellees recognized that this cause of action was against the Blumberg Trust. They actually make this admission. It was not lost on the present parties that plaintiff had named the incorrect party, and those parties acted accordingly. So in accordance with Rule 901, if you are improperly named as a defendant, there's an obligation to specify by negative affirmation that you do not have the capacity to be sued. And I've actually cited a case in my brief, the Barker decision, where they waited 2.5 years to even try to contest that. In this case, this lawsuit was actually filed in 2014, and here we are in 2020, 6 years later, and this is the first we're hearing that they were not the proper party. So this amounts to waiver of that argument on appeal. I believe that's all I have for the first part of this.
Mr. McVeigh?
Yes, thank you, Your Honor. My name's Lee McVeigh. I am a member of the Kingsport Bar and representing the appellees in this case, the Blumberg Trust and John Allen Blumberg. I will say, as I was looking during Mr. Thompson's argument, there is a reference in his brief to Rule 15.03. In his motion and brief in the court below, there's a reference to Rule 15.03. What I think the court has, and again, it's an abuse of discretion standard that the court's looking at. There are, to my mind, two rules of procedure that are in play. Rule 24 is the first, and then Rule 15 is obviously the second. The trial court, in its motion, in its order below, the trial court just broadly denies the motion.
Now, what do we do with that, counsel?
Well,
that broad denial. What are we reviewing?
Well, I think you're reviewing whether the court abused its discretion in that broad denial. Was there any anything that supported that order? Is there any avenue that the court could have used to deny the appellant's motion? And if there's any avenue, then the court did not abuse its discretion in denying that motion. And so that is part of why I understand in the reply brief, Rule 24 was not raised in our opposing motion below, but it is an avenue the court could have used below to dismiss the motion of the appellant. And so I think with that broad denial, the question for this court was there an avenue for the court below to dismiss it under Rule 24? And was there an avenue through the court below to dismiss it pursuant to Rule 15? And if the answer is yes to either one of those questions, then it's a proper denial of that motion. with regards to Rule 24, as Mr. Thompson stated, the original judgment was entered on October 29th, 2018. It's page 82 in the record. And well, I think it is actually pages 81 and 82 in the record. And to Mr. Thompson's last point that he made, if the court looks at the certificate of service on that order, which is page 82 of the record, you can see where it appears to be the clerk of court or someone has obviously marked that at one point there was a certificate of service made out to the Blumberg II Trust, and it was marked out. That was not done by the appellees because the appellees were found in default. And so it was known at that point that the wrong party had been named in this case. So in October of 2018, a judgment goes down against John Allen Blumberg and the Blumberg Trust. In July 1st of 2019, the appellants, Edgefield Holdings, purchased this debt from Regions Bank. And then 4 months later in November is when the appellant filed its motion to intervene. The case law is clear that motions to intervene under Rule 24 must be timely. And so that is one avenue the trial court below could use to deny that motion, the motion to intervene, is that it was not timely filed. The leading case in that, and it's cited in the appellee's brief, is American Materials Tech versus Chattanooga. And there are several factors that the court can consider when they are considering whether a Rule 24 motion is timely. In American Materials Tech, the potential intervening party filed their motion 27 days after entry of the final judgment. They had 6 weeks. The court found they had 6 weeks of notice to file any kind of where they were on notice of their right to intervene. And given that record, the Court of Appeals, this section of the Court of Appeals, found that could not find an abuse of discretion by the trial court in dismissing the motion to intervene for lack of timeliness. In this case, it was 12 weeks between when the appellant obtained this debt from Regions Bank and filed their motion to intervene.
Was that the reason the judge denied the motion?
Well, the judge, from my recollection, I was trying to recall that when Mr. Thompson was going over that. From my recollection, that the judge found that the order was final and could not be intervened into. But
that's not true, is it? You can intervene after a final judgment, can't you?
You can. You can intervene after a final judgment.
Right.
There's no question about that. This case, I mean, the American Materials Tech case says as much, that you can intervene after a final judgment. But even under this case, it's not a timely intervention. This particular intervention by this appellant is not a timely intervention into the case. There are also other, if we're filing under Rule 24, if we're looking at Rule 24, Rule 24.03 requires a pleading to be attached to your motion if you're going to intervene, a pleading that asserts the rights that you assert. Now, I read that, and the appellants in their reply brief point to their motion or their brief in support of that motion as being compliant with Rule 24.03. And to my mind, a pleading, whenever you're going to intervene, is a pleading that is a complaint. It states your basis and what you're saying is your right to intervene. And so, to me, our argument under 24.03 is there also has not been strict compliance with Rule 24, and that's another avenue that the court could use to dismiss the motion below.
Well, did the judge deny it for that reason?
I do not believe the judge did deny it for that reason. I could not say that.
How do we know how do we know on what basis the judge denied it?
Well, the old line is the court speaks through its orders, and the order that was entered is a very broad order. So I'm not sure exactly how to answer that without. We obviously did not have a court reporter there. We don't. I guess my best answer to that question is I don't know, other than the order itself, which is very broad. And so, but I do believe under an abuse of discretion standard, there are other avenues where either the court below or this court could find that the dismissal of that motion was not an abuse of discretion by the trial court. The other rule that's in play here is obviously Rule 15, amendment of the pleadings, and what the appellants do is use Rule 15 to change a judgment, and so these cases, the Grantham case that Mr. Thompson alluded to, the Branch case. Those cases did allow for late amendments to the pleadings, but those amendments happened during trial. They were amendments to the parties' names at trial to essentially allow trial to conform with what the evidence was at trial. There's also case law out there, as Mr. Thompson has pointed out in his briefs, that say that you can amend the pleadings after judgment has been entered, but those cases make it very clear that those pleadings are allowed after trial to conform to the evidence that everybody saw appear at trial. In this case, no trial occurred. There's a distinction between the procedural history of this case and what those cases through their procedural history hold. Rule 15.03. Right now, we're more than a year after the motion was filed, more than a year after judgment, and again about 12 weeks after the appellants obtained their rights to intervene. And so essentially what appellants are trying to do is use Rule 15 to circumvent the requirements of Rule 59 in altering or amending a judgment. Now, of course, Rule 59 requires that to be filed within 30 days of when a judgment is final. And again, it's simply a timeliness issue. What appellants are looking to apply Rule 15.03 to relate that amendment back to the original pleading, which then has the effect of coming forward and amending the entire judgment. And that's just simply not what the rules of civil procedure allow for. Even if it was a timely motion under Rule 24, it's not a timely motion under Rule 15. The trial court was proper in dismissing it, and this court should uphold that order.
Any questions? Thank you. All right, Mr. Thompson, you have 5 minutes on rebuttal.
Thank you, Your Honor. I just wanted to mention that, not one time, if you look at the pleadings that the appellees even mentioned, Tennessee Rule Civil Procedure 24 as shown in their response at the trial court. It's also not properly designated under Rule 27B as a designated issue. So the framing of the issues are as my client drafted them. Otherwise, case law does suggest that can amount to a waiver by not reframing issues or engaging in one of the three options that the appellee would have had. The facts show that the response in the trial court was clearly under Rule 15. Even the responses that were filed established that. So despite all that, I'm going to go down with some of the responses on the motion to intervene. It said that it wasn't timely. As you heard, July 1st of 2019 is when the judgment was assigned. I received that in my office sometime in November, at which point we sought to intervene as quick as possible. But I still believe that that's timely. I understand that they cited a case that says that waiting 6 weeks when you should have known that you needed to was not timely. In this case, just in reviewing this alone, nothing appeared abnormal from the judgment until I took a look at it and said, oh, this just needs to be cleaned up as the caption. This is just a mislabeling. As far as the second prong, they say that we do not have a substantial interest, and we do. We were assigned a judgment, we pay consideration, and we seek to enforce that judgment. And as far as complying with Rule 2403, we did file a brief. The rule does say that a pleading must be in support of that. I've never found that a complaint is specifically what that's referencing to. That can be done at times. In this case, if a pleading had been attached, it would have showed the Blumberg 2 trust, the number 2, instead of it saying the Blumberg trust. We're actually not seeking any rights greater than our assigner. We actually want the judgment to be upheld. We just want to fix the mislabeling of this and show that this was against the Blumberg trust. We're not seeking relief under Rule 60 or 59. We're not trying to alter a judgment. We want the judgment to stand. We're just trying to fix the style of the case and the caption as it is. As far as what we have with our order from the trial court, it wasn't a summary judgment motion, so we do not have detailed findings of fact and conclusions of law. We do have just a very broad order. And I would ask the court that based upon the pleadings, those were obviously the issues that were presented to the trial court under Rule 15. And that's how the issues were decided. So we'd ask that we say that the trial court has abused its discretion in denying Edgefield's motion to amend, and that, as I stated, Rule 1001 is just a technical requirement, but we've met that burden in establishing that this was against the proper party. It's just missing that number 2. There's been no prejudice on the parties because they knew from the beginning this judgment was against them. All they had to do was flip through the exhibits and they would have known exactly that. It was mentioned 10 times in there, and they never contested it until 6 years later, which was required under Rule 9. And for those reasons, we would ask that the trial court's decision be overruled.
All right. Thank you, gentlemen. We appreciate your argument, and we will consider the record and get your opinion as soon as possible. Thank you very much. That will end this case.
All right, thank you.
Thank you.
This honorable court is now in recess until 3:30 p.m. Eastern Time.